But it's a different charge, it's not a lesser included alternative cause number that he pleads to along the court for us, so I need to know if he's gonna do it later.
6.
Separate charge or
It's just a bit.
want to charge. For some reason, they don't want to stay in center. Trial case that's not. I think probably.
Back January. Good job. See if we can get him on the jail docket. We have a plea offer.
I mean, we're having this kind of that.
All right, I'm going to begin calling the docket. When I call your name, please say present or here. Raise your hand so I can mark you down for the docket. And then after that, counsel, whoever's ready, we'll form a line over here. There's not very many of you today, but that way I'll know who's ready to go. Ernest, Bowie or Bowie. Ernest, Jerome, Bowie. Brock Coleman. Thank you, sir. Jennifer Culpepper. Jennifer Culpepper. Ashley Duran. Ashley Renee Duran. Vincent Freeney. Vincent Larone Freeney. Freeney. Okay, it's okay. I don't need you to come up. I just acknowledging that you're here. Matthew Gould. Mahar Hamdan.
I'm here.
Thank you, sir. Tad Russell.
Present.
Thank you, Ms. Beasley. Sergio Villarreal. Sergio Arturo Villarreal. You're looking a little white this one. Leon Baker. Leon Thomas Baker. Tavares Dixon. Amber Martin. Bryce Carroll. Matthew England. Damon Gutierrez. Damon Jacob Gutierrez. You know anything about Mr. Gutierrez, Mr. Ashmore?
I'll call him down that. I hope he's feeling better.
Alicia Harris. Alicia Gail Harris. Oh, is that the one we took? Oh, thank you, Mr. Waddell. Cameron Roberts. Giovanni Chavez Rosales. Giovanni Chavez Rosales. that set for a plea today?
Yes, it is.
Tyler Donica? Thank you. Heather Keels? Heather Lynn Keels? Ray Moore? Thanks, sir. Edward Woodall? Damon Jackson?
Set it over.
Set at 11. So not here. Right. Thank you, Mr. Woodward. Is there anyone whose name I've not called that's present in the courtroom? You're here and I've not called your name. What's your name, sir? Joe White. Mr. White on Tuesday's docket, I believe.
I believe so, Judge. He wasn't one of our nice guys.
That next docket date is 1/6. Set for 1/6. Mr. Ash, where's Mr. Ash? It's okay. So my understanding is that Mr. White was set January 6th. Ms. Abraham says it's been communicated that we got a medical procedure and y'all asked him to come on this docket so we could work around the medical procedure. Is that right? Okay. All right. I'll write him in. Is there anyone else who's present in the courtroom and I've not called your name? You may.
Judge, I have a new offer on a case that's specially set in January, Mr. Reynolds. I'd like to be excused to go to the jail to talk to him before I'm unable to. I know it's just manpower problems. It gets jammed up. They don't like us visiting after about 10 or 10:30. So if I could just be excused for about half an hour. Austin's here to make sure we don't clog you up. I'll be right
Yeah,
now.
can you not talk to him this afternoon? Because I've got you there this afternoon.
Well, they won't, they're not set. They won't bring them up. They just don't have the manpower.
One judge,
I'll tell you what, I'll make sure you see this afternoon.
judge, hypothetically, this might be the hypothetical I gave you this morning, which would require us to file additional paperwork, which is probably ask Mr. Ashmore to figure it out sooner rather than later.
So you want to talk about it before he goes over and talk to his mom?
Well, he and I have already talked to it, but if his client is going to accept the alternative charge, we will need time to file an duplicate the case, file an information, all of those things.
But y'all still want to present to me to see if I can accept it?
We can. Mr. Ashmore sent me a pretty convincing text, but I would like to double check that you find that convincing as well, Judge.
So I'll tell you what, let's hold off from going.
Okay,
over there, 'cause
no
I mean,
problem.
You got several this morning.
I do.
I don't want to fall behind, so hold up on that. We'll talk on break and then if you need
Perhaps-
access to it, I'll make sure you get access.
Okay,
to it.
that sounds good. Thank you, sir.
All right, council, do we have anyone that's ready? Mr. White, are you ready?
Yes, sir.
You ready on Mr. Moore?
Yes, sir.
Mr. Moore, if you'll come to the podium, sir. This is CR 21230, State versus Ray Moore Jr. Set for docket call. So understanding, Mr. White, that you're requesting additional time.
I am, Your Honor. I've talked with Ms. Heisel. I believe she'll join me in that
request. We feel like that there's a better than average chance that this case will resolve out. We're just trying to figure out the proper resolution.
No objection from the state, Your Honor.
Mr. White, I believe you were wanting something in February, is that right?
That's correct, Your Honor.
Any objection? You want early February or later February?
We could probably do later February. That'd be better.
Stating the objection to February 22nd.
No, Your Honor.
All right. Mr. Moore, the court's going to reset your case for docket call on February 22nd. And that'll be at 9 a.m. Mr. White's got a form for you to sign. Once you get the yellow copy, you are free to go, sir.
Thank you.
You're welcome, sir. You ready, Mr. Woodall?
Yes, sir.
Edward Woodall, CR 21-255. All right, Mr. Woodall, set for docket call today.
That's correct, Your Honor. The state, and I have discussed this case, Ms. Heisel and I have, I think, I think the state's made an offer. I need to, it's a new offer. I need to get Mr. Woodall and we need to talk about, I don't need just a real long time.
Any objection from the state?
No, Your Honor.
Available February 8th.
Yes, sir, that'll be good.
All right, Mr. Woodall, the court's going to reset you until February 8th at 9 a.m. Once you get the yellow copy, you're free to go, sir. Ms. Beasley, do you just have tablets?
Yes, Your Honor.
Please, let's go. Is that all you have, Mr. White?
Your Honor, I got a couple of things this afternoon. Court also were allowed us to take an eyesight on this back. Mr. Rabbit did contact my office this morning.
Ms. Beasley. Tad Russell. This is CR 21-339 and 340, State versus Tad Michael Russell. And we are set for pretrial on the aggravated assault deadly weapon charge, and we're set for arraignment on the unlawful possession of firearm by felon charge. Ms. Beasley, is that right?
I guess that's right, Judge. I wasn't aware of the second one. I'll need to get a copy of the indictment and go over that with my client. If I can have just a minute, Judge. Just a few minutes to recall the case.
Sure, I'll tell you what. Well, let me do this for you. Let me just pull it up, and if you can, I'll display it here, and I'll let him come up here, and y'all can. You can either do it there, or you can come up to the TV and. And if you want to, y'all can walk over there if you want more privacy.
Thank you, Judge.
You're welcome. Yes, ma'am. All right, you ready, Ms. Beasley, on the arraignment?
Yes, sir. My client on his second new case on unlawful possession of firearm by a felon understands the nature of the charge, the punishment range. His name is spelled correctly in that indictment, and he wishes to enter plea of not guilty to that indictment as well.
All right, court will enter Mr. Russell's plea of not guilty to the charge of unlawful possession of firearm by felon. Court will set this matter for pretrial and run it concurrent with the aggravated assault deadly weapon. Court will reset both for pretrial, so I'm not going to ask for an announcement on that unless you know that you have a contested motion, and I understand that you're not going to be able to stay on this case.
Right, Judge. I'm gonna have to withdraw. I've gone over all of the information with my client, and I cannot get it resolved before I retire.
Have you already had that discussion with Mr. Russell?
Yes, I have. Several times we've gone over the information, the plea offer, and everything. He understands that I'm retiring and understands he wants to resolve it with a different lawyer later date.
Give me just one moment. Please, is there a co-defendant in this case at all?
No, sir.
All right, Ms. Russell, just have a seat, and we're going to look at appointing you new counsel since Ms. Beasley is going to be retiring. So we're going to switch attorneys for you. So just have a seat. We're going to get that squared away in just a moment, okay? Thank you. You're welcome, sir.
And Judge, I've already filled out the reset sheet. Would you like me to leave it in the courtroom so that we can fill out a date?
Yeah, you just give it to me that way. If you're going to go ahead and leave, have you filed a motion to withdraw at all, or do you want me to just read one? Sorry for the break. Yes, sir. Tyler Donica, CR 21285. All right, Mr. Donica, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Mr. Donica, your name is Tyler Scott Donica, is that right? Mr. Donica, are you a United States citizen?
Yes.
And have you ever been diagnosed with any type of mental condition? And you do read, write, and speak English, is that right? And in this case, you are represented by your attorney, Mr. Joseph Murphy. Are you pleased with his representation of you?
Yes, sir.
Like you've had enough time to discuss the case with him and have all your legal questions answered? Is there anything about the paperwork in this plea agreement that you have read and signed that you do not understand? Mr. Murphy, do you believe that your client is competent today?
I do, Your Honor.
And you've explained to him his legal rights?
Yes, sir.
And do you believe he understands them?
I do.
Mr. Donica, you are charged by indictment with a first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1, greater than or equal to 4 grams but less than 200 grams. The range of punishment for this type of offense, if convicted and sentenced, is confinement in the Texas Department of Criminal Justice for not less than 5 years or more than 99 years or life, and a fine not to exceed $10,000. Do you understand that potential range of punishment? And I see that you want to enter into a plea agreement wherein the court would defer a finding of guilt. That means not find you guilty. You would plead guilty. The court would not find you guilty. Court would place you on 6 years of deferred community supervision, assess a $5,000 fine plus restitution and court costs and reimbursement fees. And the state would be asking the court to dismiss 2 other charges, both one a possession of marijuana less than 2 ounces, and then another possession of a controlled substance. Is that the plea agreement you want the court to approve?
Yes,
And do you understand, Mr. Donica? I'm confident that Mr. Murphy has explained this to you, but I think it's incumbent upon me to make sure as well that if I approve this and you're placed on community supervision, and you're given several conditions that you have to comply with, if you violate one of those and the state brings you back on a motion to adjudicate your guilt, that means a motion to convict you and to revoke your community supervision. At that hearing, if the court determines, based on the evidence, that you violate one or more of those conditions, the court could adjudicate your guilt, convict you, make you a convicted felon, first-degree felony, and the court could then assess your punishment anywhere from the minimum 5 years all the way up to maximum life in prison. Do you understand that? You thought through this and understanding the potential risk, understanding what the conditions of community supervision are, you still want to go forward with the plea. Is that right? All right. Mr. Donica, understanding the range of punishment and the plea agreement, then how do you plead to manufacture or delivery of a controlled substance of penalty group 1 greater than or equal to 4 grams but less than 200 grams? Mr. Donica, are you pleading guilty because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty today? Court accepts the defendant's plea of guilt. Mr. Murphy, any objection to the state's evidence?
no, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor, we would rest those.
from the defense?
Rest of those as well.
All right, Mr. Donica, did you just turn 21 this year? All right, Mr. Donica, based on the evidence before the court finds that there is enough evidence to convict you of this offense. The court will follow the recommendation of the state in your plea agreement. Court hereby defers a finding of guilt, places you on 6 years of deferred community supervision, orders you to pay a $5,000 fine, $290 court cost, orders you to pay $35 reimbursement fees, and $180 restitution. Mr. Donica, have you ever been on probation before? No? Where you're starting out with what I would say is the highest probation a court can impose. That being a 10-year, but this is a 6-year deferred, so almost the maximum deferred on the highest degree felony, other than capital. So you're gonna have a lot of risk, you're gonna have a lot hanging over your head for the next 6 years. At 21 years old, I'd hate to see you not take it serious and wind up in prison for a very long time. Understand? Are you a student? Do you have a job? You have a job? Well, I know that Mr. Murphy has already told you, because I'm confident of it, because I know Mr. Murphy, and I know how he practices law, and I know his experience. And I'll just stress probably what he's already stressed to you is that you better be by the book. You better go over there and not be a problem to your probation officer, do everything that you're supposed to do, and avoid ever having to come back before the court, and avoid having a judge like myself or anyone else be in a position to have to tell you how you're going to live the rest of your life behind bars or not behind bars. You understand? All right, Mr. Donica, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. Do I have the probation conditions? I don't know that I've seen those. Do you have those? Has he gone over the probation conditions? We do now. All right. Mr. Donica, if you'll come forward to be fingerprinted by the deputy. After that, I want you to step over here with the officers and they'll give you more information about the next step. Yeah.
Tried to fold it. Jeez. Mr. Gould,
Come back here and meet with Mr. Waddell before I call your case, please. Here, you want to take this? Take that. Mr. Freeney. All right, Mr. Freeney. This is a sanctions court hearing, so you don't have to. All right, Mr. Freeney, this is a sanctions court hearing. Progress report says that you were to pay 110 to probation, 280 to collections, and work 10 hours of community service. And everything indicates here that you didn't do any of those three. Can you give me an update on that?
I did everything.
You did everything?
Yes, sir.
When did you pay your 110 to probation?
Monday.
When was it due? Was it due the Friday before?
No, I said on the 13th.
On the 13th? All right, come back here and meet with Officer Matura, and then you just make cases again.
It's not just if he's out of state. Not gonna be in jail.
Okay, Your Honor, we're ready to proceed on the record.
All right, this is CR 21-211 State versus Tavares Trail Dixon set for arraignment. Go ahead, Mr. Adams.
Thank you, Your Honor. On behalf of Mr. Dixon, Mr. Dixon and I have just finished reviewing a copy of the state's indictment. I can represent to the court that Mr. Dixon understands the allegation made in the indictment against him. His name is properly set forth and spelled in the indictment. He is the same Tavares Dixon named in the indictment who was in the courtroom here today. On behalf of Mr. Dixon, we'd enter a plea of not guilty to the offense, waive a formal reading of the indictment, and ask the court to set us for a pretrial hearing.
All right, court will enter Mr. Dixon's plea of not guilty into the record. We will set this for pretrial. Remind me, Mr. Dixon, what state do you live in?
Louisiana,
Louisiana. Where at Louisiana?
Alexandria, Louisiana,
So how far of that is the drive from there to here?
4 hours.
4 hours. Do you know when you're coming back in February, Mr. Adams? I got a couple dates. I want to make sure I'm working with your schedule.
Sure.
We're back on February 8th, 10th, and 22nd.
Tuesday, the 8th, Your Honor.
All right, court sets Mr. Dixon for pretrial on February 8th.
Nine o'clock.
What time do you leave to get here?
Here
On court days, what time do you leave your house?
at night, I leave at night.
Oh, you leave at night? You stay overnight here? If I moved it a little bit later in the morning, would that allow you to leave in the morning there? Or if I set it at 10 o'clock
Yes, sir.
or 11 o'clock?
Yes, sir.
Travis, do you have any objection to that?
I don't.
How about 11 o'clock
That'll
on the
work.
8th?
That'll work.
Thank you, Your Honor.
All right, court sets Mr. Dixon then for 11 a.m. on February 8th. So, Mr. Dixon, once you sign and get the yellow copy, you can come over here and meet with Officer Waddell. He's going to talk to you about how you're going to report while you're on pretrial release. Okay? Amber Martin, CR 2179. All right, Ms. Martin, if you'll raise your right hand, we'll place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you may put your hand down. Make sure you speak up loudly and clearly so my court reporter here can hear you. Okay? Is that microphone on? Is it green right there? Do you see the green light?
Yes.
Okay, there you go. And if you're soft spoken, just you can speak kind of directly into that. All right, Ms. Martin, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Mitch Adams. Are you pleased with his representation of you?
Yes.
Do you feel like you've had enough time to discuss your case with him, have all your legal questions answered?
Yes.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No.
Mr. Adams, do you believe Ms. Martin to be competent today?
She's competent, Your Honor.
You've explained to her her legal rights.
That's correct.
Do you believe she understands them?
I believe so.
Ms. Martin, you appeared before the court on October 20th of 2020. You pled guilty to the offense of abandoning or endangering a child intentionally, knowingly, or recklessly, or with criminal negligence, a state jail felony. After hearing the evidence, the court found that there was enough evidence to convict you of the offense. However, the court followed a plea agreement on that date and deferred a finding of guilt and placed you on community supervision for 2 years and also assessed a $1,000 fine. It was during your probationary period that the state filed a motion to adjudicate, that means to convict you and to revoke your community supervision. And they have alleged 11 separate accounts of ways that you violated your conditions of community supervision. Have you had enough time to read over that and understand that with your counsel, Mr. Adams?
Yes.
Mr. Adams, does your client waive the formal reading of the state's motion?
Yes, Your Honor, we waive the formal reading.
Is it her intention to plead true to all counts?
It is.
All right, Ms. Martin, I'm going to ask you at this time, how do you plead to counts 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and 11? Are those counts true or not true?
True.
And are you pleading true to those counts because the conduct alleged in those counts is true?
Yes.
Has anyone threatened, forced, or pressured you to plead true today?
No.
All right, court accepts the defendant's plea of true. Mr. Adams, any objection to the state's evidence?
No objection.
State's evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor, we rest.
So I'm gonna need some help on this one. There's a lot of violations. Why would the court think that probation is gonna be different for Ms. Martin than it was 2 years ago? All the way up to her using methamphetamine just a few months ago.
Well, Your Honor, Ms. Martin had a stretch when she was initially placed on probation where I think she was doing reasonably well by abiding by the conditions. She was involved with an individual who is an addict and who she allowed to induce her to use this past summer. Since that happened, and since she was arrested on the warrant that resulted in that, she's been diligent in attending Alcohol Anonymous and Narcotics Anonymous meetings. She's been clean, albeit it's not the longest period of time in the world, of course, but she has been clean and sober since her use this past earlier this year. In talking with Ms. Martin in my office, it's clear to me that she understands now that she is no longer involved with that individual and is no longer using chemicals or other illicit substances. That she understands what's important here is that it's not necessarily her, but it is her children, and she cares very, very deeply about that. And she understands that in order for that, what benefits her children, and she understands that in agreeing or accepting the probation, the consequence of this as a probated sentence, if the court's willing to oblige her, that's going to benefit her, of course, by not having to serve time in a state jail facility, but also it's going to benefit, or more so, it's going to benefit her children.
Did she report to probation after she got out of jail? Has she been reporting since the filing of the motion?
She has been. She reported to probation back in the summer, knowing there was a warrant there waiting for her.
And then after she posted bond, she continued to report your community service, drug test, all those things.
That's correct.
Is that right, Ms. Martin?
Yes, sir.
So I've heard from Mr. Adams. Let me hear from you. Why should I put you back on probation?
I'm serious about it this time. A lot has changed.
He's told me some things. I want to hear what's changed for you.
I got out of a really bad situation. I have a really good job, my own place. I'm actually doing really good in my good spot.
How many kids do you have?
F3.
Are they in your care?
No.
Whose care are they in?
My oldest is with his father. He lives right under us, so I can see him pretty much whenever I want. My other two are my younger two, and they live in Fort Worth, but I get to see them every 2 weeks.
Are they in your family's care or are they?
My husband's mother.
Your husband's mother?
Yes.
Ms. Martin, would you mind telling Judge Martin what you told me about your arrest this past summer? Your attitude toward being in jail versus where your living conditions at the time?
Where I was living was really, really bad, so jail was better than where I was living. So I was kind of happy to go to jail, and I've been clean and out of that situation since it happened.
So you're telling me that if I put you back on probation, you're going to be a different person than what's reflected in all of this?
Yes, sir.
Completely different.
I am different. Yes.
You're going to report, you're going to be clean, you're going to do your community service, you're going to pay, you're going to do everything you're supposed to do. Because what I hold right here tells me you didn't do anything.
Yes.
I mean, that's almost a violation of every count, of every condition. Typically, I love baseball. It's not a baseball field. I don't play the 3 strikes and you're out. Understand?
Yes, sir.
So it's hard for me to accept it. Because I'd rather say you're an adult, you make decisions, you screw up, you make these decisions, you pay the price. There's consequences for actions. That's what I believe the law requires us to do. So it kind of goes against my gut. But you're telling me if I do this, that I'm not going to regret it, and that if you do screw up, you're just going to come in here and you're going to sign for the 2 years, day for day?
Yes.
Yes, or I guess?
Yes.
Yes.
Sorry.
And you understand that if you violate, if you go back to hanging out with bad people or get in that situation and you make that decision, sentence is already set. It says 2 years TDCJ. It says that's what you're going to get. And you understand that's day for day. There's no parole on that.
Yes.
All right, the court will follow the plea agreement. The court hereby finds that there is sufficient evidence to convict Ms. Martin of this offense. The court will find that she has violated the terms and conditions of her community supervision. Court will adjudicate her guilt, convict her of abandoning, endangering a child with criminal negligence. Court will assess her punishment at 2 years confinement in the Texas Department of Criminal Justice. Court will suspend that sentence, place her on community supervision for 2 years. Court will order her to pay the balance of her financial obligations. All right, Ms. Martin, I've done my job. Your turn to do your job. Understand?
Yes, sir.
All right, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with the deputy. After that, have a seat over here and somebody from the probation officer will be with you shortly.
Judge, I think that wraps it up for me for the morning anyway.
I think so too. Is Leon Baker here? Thank you, sir.
I can field a basketball team with what I've got for this afternoon, so I'll see you then.
Good. Okay, well, let's play ball then. Mr. Manning, are you ready? Yes. Chavez Rosales. Giovanni Chavez Rosales. All right, Mr. Chavez, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. You're going to have to speak up loudly and clearly so my court reporter here can hear what you're saying, and so I can hear it. She's got to take it all down, okay?
Yes, sir.
Is your name Giovanni Chavez Rosales?
Yes, Your Honor.
And are you a United States citizen?
Yes, Your Honor.
Do you read, write, speak English?
Yes.
Have you ever been diagnosed with any type of mental condition? No?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Thank you.
Are you happy with the way Mr. Manning has been your attorney?
Yes, Your Honor.
Is there, do you feel like you've had enough time to discuss your case with him and have all your questions answered?
Yes, Your Honor.
Is there anything about this paperwork that you do not understand? You've read through this and you've signed it, is that right?
Yes, Your Honor.
Okay, is there anything that you don't understand today?
I do understand.
Do you understand?
Yes, Your Honor.
Mr. Manning, do you believe that your client is competent?
Yes, Judge.
You've explained to him his legal rights?
I have, Judge.
You believe he understands them?
He does.
All right, Mr. Chavez, the papers reflect that you have been indicted with a third-degree felony offense of evading arrest or detention with a vehicle. It carries a range of punishment between 2 years and 10 years and a fine of not more than $10,000. I see here that your plea agreement is that you're gonna plead guilty to that offense. The state's gonna recommend that you not be convicted today, that you be placed on community supervision or probation for 4 years and a $2,500 fine plus court costs and other fees.
Yes, Your Honor.
If the court approves this and places you on community supervision, you've read through your conditions of community supervision, right? You know what you're supposed to do, right? If you violate any of those, the state can file a motion to convict you. They can bring you back and they can ask this court to put you in prison anywhere from the lower minimum of 2 years all the way to the maximum of 10 years and assess a fine all the way up to $10,000. Do you understand that?
Yes, Your Honor.
Understanding the range of punishment in the plea agreement, do you want to go forward with the plea?
Yes, Your Honor.
All right, so Mr. Chavez, then how do you plead to evading evading arrest or detention with a vehicle. Guilty or not guilty?
Guilty.
Are you pleading guilty because you are guilty of committing that crime?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, Your Honor.
My court accepts the defendant's plea of guilt. Mr. Manning, any objection to state's evidence?
No objection, Mr. State's one.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state,
No, Your Honor, redress of those.
from the defense?
Rest in close, Judge.
All right, the court has reviewed the evidence, finds sufficient evidence to convict Mr. Chavez of this offense. Court will follow the plea agreement recommendation of the state of Texas. Court hereby defers a finding of guilt, places Mr. Chavez on 4 years community supervision, orders him to pay a $2,500 fine, $290 court cost, $35 reimbursement fees. Mr. Chavez, in reading your case, made some very stupid decisions that night.
Yes, Your Honor.
You're lucky you didn't kill anybody. You know what would have been, what kind of charge that would have been if one of your passengers in your car would have died, or one of the officers would have died, or any one of the other people around you where you were endangering their lives. You know what the charge would have been?
Like 20,
Hmm?
20 to 30.
No, I mean, what do you think they would have charged you with? If you would have killed somebody while you were committing a felony murder. Committing an act clearly dangerous to human life while you're committing a felony, 5 to 99 or life. How old are you?
20.
20. 20 years old. You're lucky. You're very lucky that no one was hurt that night. You're lucky that the worst you got was taken out of your car at gunpoint, indicted by a grand jury, brought to this court, and you're being given a great opportunity to not have this on your record. You know, you were that close. I mean, you can't control what happens out there. If any one of those would have died, you'd be looking at life in prison. You probably would have gotten it. Understand?
Yes, Your Honor. It was just a one-time mistake.
I hope so. I hope so. I hope you don't come in here and say you made a mistake in violating a condition of your probation. Because if you violate your conditions of community supervision and they bring you back in here, if I have to assess sentence on you, you know what I'm gonna go back and read? I'm gonna go back and read this offense report, and you driving 130 miles an hour, endangering lives of officers and other motorists. That's what you get sentenced on. If you drink a beer, or you smoke weed, or you don't do your community service, I don't send people to prison for smoking weed or doing that when they're on probation. I find that to be a violation, and I sentence them based on what their crime is. This is what you pled guilty to.
Yes, Your Honor.
Understand? All right, Mr. Chavez, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with the deputy, and then have a seat over here, and somebody from the probation office will be with you shortly. Mr. Chavez, close office.
Yes.
She's coming back.
So just giving these 2 sets of information.
Mr. Coleman, Brock Coleman, CR 17-6. All right, Mr. Coleman, I've reviewed your request for court-appointed attorney. Based on the financial information you provided, I show that you have assets that would be sufficient enough for you to hire an attorney. And so under the law, you do not meet the requirements for court-appointed counsel. So if you have a car that's worth $8,000 or $9,000, go out and get a loan on that. Use that as collateral to secure a loan to pay an attorney. Okay, so what I'm going to do is I'm going to reset your case, give you time to make the arrangements to hire an attorney to represent you. Okay. All right, I'm going to have you come back on January 27th at 9 a.m. The deputy has a form for you. Sign that. We'll give you a copy of it. This is Brock Coleman, CR 17-6. On my first page. No return. You're free to go.
Thank you.
And Mr. Coleman, make sure you're still on probation. Still need to report.
Live here anymore. I live in Webster. I was checking into Baytown probation, and after this happened, I had an appointment and I went to go check in. She told me my case was no longer with Baytown.
Usually once a motion to revoke or motion to adjudicate is filed, it goes back to the original. So why don't you come back here and meet with the officers and they'll get you set up, okay? Yeah, so if you have personal belongings, you can grab those and then you can come back here and meet with Officer Waddell. They'll give you some directions on where you go, okay? Report, Mr. Stevens.
Can you hear me, Judge?
Can't hear you. Yes, sir.
All right. I apologize for not being there, Your Honor. It just slipped up on me and I didn't have it on my calendar.
It's okay. The state moved for sanctions. You weren't here. I granted it. It's just money, right? You don't, right?
Hey, I'll be over there jail this afternoon, so just cuff me when I get there, Judge.
We will give Mr. Stevens the vacation that he richly deserved.
You'd rather go to jail than lose money, right?
Really.
All right, I'm looking for Miss Kills. I think we just taken a small recess, so she may be outside.
All right, sir.
She did. She was late, but she did appear.
She wasn't here when you called the doctor.
Yeah, I called her. She wasn't here, and then they told me that she had come in just a few minutes after. Yes, Ms. Kills, if you'll just come up to that podium, please.
How are you today?
Doing fine. Mr. Stevens is there. Can you see him on the lower left?
Yes, sir.
All right, Mr. Stevens. This is cause number CR 21330, State versus Heather Lynn Kills. We are set for arraignment today. Have you had an opportunity to go over the indictment with Ms. Kills?
I apologize, Your Honor. I have not.
So what I'm going to do is share screen here. Ms. Kills, on that laptop right in front of you, can you see this document? Can you see it? Okay. If not, if you need to come up here to the TV, you can come up here to this TV also. If you need to make that bigger here, I don't know.
I stepped on mine this morning.
You have your readers. She have extra readers. Yeah, she has extra readers. All right, Ms. Kills, have you had a chance to read that indictment?
Sir.
Okay, so let me ask you a couple of questions. Do you see where your name is in the middle of that document where it says Heather Lynn Kills?
Yes, sir.
Is your name spelled correctly there?
Yes, sir.
Okay. And in this indictment, it's alleging that you, on May 2nd of 2021, intentionally or knowingly possessed a controlled substance, methamphetamine, in an amount of less than 1 gram. It's
Yes, sir.
repeated here at the top. So that's the crime that you're being accused of. Okay. The range of punishment for a state jail felony is confinement of not less than 6 months or more than 2 years in the Texas Department of Criminal Justice State Jail Division. So that means if you are tried and convicted, or if you're placed on deferred adjudication and later convicted, that would be the range of punishment. Your sentence would have to be lawfully set between 6 months to 2 years. Okay. So at this time, Mr. Stevens, I have admonished her of the range of punishment, and I pointed out to her the elements of the indictment and that her name is spelled correctly. Did your client waive the formal reading of the indictment at this time in which to enter a plea?
Yes, we do, Judge. We'll waive for formal reading and enter plea of not guilty at this time.
All right, court enters Ms. Keel's plea of not guilty into the record, and we will set this for a pretrial hearing. I'm already pretty much booked in January, Mr. Stevens, so we're looking in February. I've got February 8th, 10th, and 22nd. I don't know if you're already scheduled to be here or not. Do you know?
8, 10, and 22. I'm looking right now, Judge. No, sir, I'm not. So whatever you prefer, Your Honor, will be fine with me.
All right, well, let's go ahead and we'll put you on the 8th,
All
February.
right, sir.
All right, so Ms. Keels, I'm going to have you come back to court on February 8th for a pretrial hearing, and you still have Mr. Stevens' contact information
Yes, sir.
on the form that's got his address and everything. That's how you'll stay in contact with him. And Mr. Stevens, I'm going to order Ms. Keels to be placed on conditions of pretrial release, just like every other
Yes, sir.
defendant. So you're going to sign this notice form with the deputy. Once you get the yellow copy, you're going to report to the pretrial release officer here in this room, and they're going to give you some information. You're going to have conditions of pretrial release that are associated with your bail. You're going to have to report. You're going to have to make payments towards Mr. Stevens' indigent attorney appointment, bond supervision. You're going to have to be drug tested. You're going to be ordered to not commit any new offenses, consume any illegal substances or alcohol, things of that nature. Okay.
Yes, sir.
Did you have a question?
Can I do community service by any chance?
Well, so what you're going to do, so we're early on in this process. So you'll go back there and you'll talk to them about the pretrial release. And then Mr. Stevens, you'll discuss all that with Mr. Stevens, and he'll discuss that with the state's prosecutors to see if there's a plea agreement in this case. And if one can be reached, your attorney and the state's attorneys will work that out. Okay.
Yes, sir.
All right. So go ahead.
Your Honor,
Yes, go ahead. Mr. Stevens.
would you ask Ms. Kills to give my office a call when she leaves the courthouse?
Yes, sir.
She heard you. She said she would.
I'm sorry, Judge.
She heard you and she said she would.
Oh, okay. And who's my prosecutor on this case? Is it Tyler?
I believe it is.
He says he believes it is him.
Okay, Tyler, I need the discovery. I checked the computer when we're online and I don't have it yet.
I will make sure that it is taken care of very shortly.
Okay, and Tyler, one more quick thing, if you don't mind. I've got a plea this afternoon at the jail. Should I stop by your office and pick up the papers before I head to the jail or what?
We will have it available at our office, but prior to.
Okay, I'll come by and pick it up when I'm headed to the jail then.
Okay,
Hold on, Mr.
hold
Stevens.
on.
He can hear you from there.
Okay.
As long as you're on the microphone.
Okay.
We got all that corrected, so he should be able to hear you.
Mr. Stevens, we will send the paperwork to the jail with Ms. Taberham.
Okay.
We're not taking it back to our office because then there's, I mean, I guess we just keep it all together so everybody knows
Okay.
where it's at.
Sounds good to me. I'll just pick it up there.
All right. Thank you, Mr. Stevens. All right, Ms. Keels, you've got that yellow copy. Come over here and go through this door and have a seat, and they'll give you further instructions. Okay. You as well. All right, Mr. Stevens. I guess we'll see you this afternoon.
Thank you, Judge. Again, I apologize for not being here. I just dropped the ball.
No problem. Pay that sanction. We'll be fine.
Okay, thanks, Judge. See you later. Bye.
All right. This is cause number CR 1576, State versus Mahar Hamdan. The state prosecutors have filed a motion to adjudicate your guilt. All right. So the court has appointed Ms. Casey Chester as your attorney. I believe that you have the paperwork now that has Ms. Chester's contact information on there. So I'm going to reset your case for January 27th. And in the next couple of days, I want you to give Ms. Chester a call, and she will then work with the state's prosecutors on your case. Okay. And if you have any questions about your probation conditions or trying to report, and once you sign this with the deputy and you get the yellow copy, then you can come through this door over here and speak with the probation officers, and they can give you more information. But you need to contact your attorney here within a day or two. She's not going to have any of this information today because she just got appointed. She's not here. She's not aware. But you can let her know that she's been appointed to your case, and then she'll reach out to the prosecutors and get more information for you. Okay. All right. So you'll sign right here with the deputy. Do you have Yes, sir. Mr. Ashmore, are you ready?
Judge, I'm ready. Everybody but Mr. Carroll, so I'll ask you if we can take him last, as we need one piece of information before we can plea him.
Matthew England, CR 21356. All right, Mr. England is set for arraignment today. Have you had a chance to go over the indictment with him?
I have. The state was kind enough to give me that indictment this morning. I've reviewed it with Matthew in the hallway. He understands that it is a assault, third-degree felony. We've talked about the punishment range. He has confirmed that his name is spelled correctly, both places in the indictment. He understands the allegation is said to have occurred on June 30th, 2021. The what, when, and the why of it. He's authorized me to enter a plea of not guilty at this time and work with the state to get a pretrial offer. And so we'll ask the court for a resetting for pretrial, Your Honor, at the court's convenience.
All right, court will enter Mr. England's plea of not guilty into the record. We'll set this matter for pretrial, looking at 3 dates, February 8th, 10th, or 22nd.
I think that special setting still on the 8th, so can I ask for the 22nd, Judge?
Court will set Mr. England then for pretrial on February 22nd at 9 a.m. Mr. England, once you sign the notice of setting, then I need you to report to the pretrial release officer so you can sign your pretrial release conditions, okay?
Yes, sir. Thank you.
No, it was. She goes to the Soul Christian Academy. Got past those days for a while.
Cameron Roberts, CR 19290. This is hearing on the motion to revoke.
Judge, we are asking the court to reset this to the contested docket. Mr. Roberts has provided to me, and I've provided to the state, some clean drug tests, multiple clean drug tests, as well as some hours, community service hours. The state is going to consider that information as we work towards a resolution of this matter. I think the most efficient thing, what we're asking the court to approve, is to just reset this for a contested so we can work this out. I think your next one is 27 January 2022. I think I'm already here. So if we can reset to that date, I think we'll be done before then, Your Honor.
All right, court will set Mr. Roberts for contested hearing on January 27th at 9 a.m. Joe White. Write this one. This is CR 21254. CR 21254, Joe White Jr. All right, so Mr. White, I show was set for docket call on January 6th. So it's my understanding that we've asked to have it put on today's docket to work around a medical issue.
Correct, Judge. So the state has entertained a deferred offer. We understand Mr. White does not want us to further negotiate. Just go ahead and set it for jury trial. And so I know the court's next jury trial setting is 10 January 2022. I think that or the February docket would be our request to reset this at that junction.
All right, so the state's offer was what deferred?
We didn't even get that far. Okay. It was the state, it had indicated, and my notes may be incomplete, but Mr. Woodwike and I had discussed this, and my recollection is the state would definitely go forward on a deferred offer. Negotiations essentially were stopped at that point.
And that was stopped by the defendant.
Correct. At Mr. White's election and insistence.
All right, Mr. White, you absolutely have the right to have your case tried before a jury of your peers. However, I want you to know that the court has a deadline in which cases can be worked out by an agreed resolution, meaning a plea agreement. And what Mr. Ashmore is telling me is that you do not want to enter into any type of plea negotiations with the state. You're asking for a jury trial in this case. Is that correct? All right. And so you understand, Mr. White, that after today, I'm going to go ahead and set it because you have the right to have your case tried before a jury of your peers. I'm going to ensure that you get that right. And so once I set this case for trial, the case is either going to be dismissed or you're going to go to trial. And so the Friday before, if you decide, you know what, I don't want to go to trial, I want to take that deferred offer that the state was offering back, in December of 2021, I'm going to tell you no. Understand that, right? There's going to be no plea negotiations after today. And so you've thought about this and you're making this decision based on all of the information that you and your attorney talked about on your case. Is that right? Okay. All right. So the court will set Mr. White then to begin appearing on the jury trial docket on January 10th at 8:30. On that date, Mr. White, okay, so you had a medical issue going on, and are you going to be unable to appear on January 10th?
I do have two doctor's appointments, two different doctors, yes, sir.
Are they appointments or are they medical procedures? I mean, are they procedures? Are you having surgery, something being done, or you just?
We have more than likely a procedure.
When?
It's supposed to be 6th, they'll tell me.
Okay. They'll tell you if you're going to be having a procedure. I don't want to pry into your medical, but tell me, if I set you on the 10th, do you think that there's a above average chance that you'll be able to appear that day or not?
I don't think so, sir.
Don't think so. All right. Well, if I set you on February 1st, do you think you're more likely to be able to appear on that day?
Yes, sir.
Okay. All right. So the court will. Not February 1st, but on January 31st. All right, court will set Mr. White to appear on January 31st at 8:30 for jury selection. And so you'll appear down in the basement. Mr. Ashmore is not going to be required to be there. You will not be selected for trial that day. You're going to check in. My staff will have paperwork for you to tell you when the new date is. You'll continue to do that each month until your case is selected for trial. There are other trials ahead of you right now, okay? All right. So once you sign this notice of appearance, then I want you to check in with pre-trial release to make sure they don't need anything from you. And then when they say you're good to go, you're good to go. Yes, sir. Okay?
He's next.
Basically on pre-trial release. Okay. I'll have Wayne and bring you. Okay. Favor, I just print off some conditions of pre-trial release. You bring those to Rachel and the jury room.
Ed Russell, Your Honor.
Mr. Russell? All right, this is cause numbers CR 21, 339 and 340, State versus Tad Michael Russell. Mr. Russell was previously set for pretrial and arraignment today. Respectively, Mr. Russell had previous counsel appointed by the court, Ms. Debbie Beasley. Ms. Beasley is retiring and wrapping up her practice, so it has become necessary for the court to issue an amended appointment, and the court has appointed the Honorable Casey Ashmore to be counsel for Mr. Russell. Each case being set for pretrial today, the court will just reset for an additional pretrial, and I'll set that on February, did you say 22nd?
Yes, Judge.
All right, so Mr. Russell, what I'm going to do is reset you to appear on February 22nd at 9 a.m. on both of your cases. Fill out this notice of appearance to Mr. Ashmore, and then you'll be free to go. Mr. Ashmore, before he leaves, so did you and Miss Beasley?
We did.
Confer?
We've conferred, and I've had a chance to confer with Mr. Russell about both cases. I understand the offer is 15 TDCJ on the family violence allegation and resolution of all other matters. We've talked about that with Ms. Beasley. We've talked about that with Mr. Russell. And again, we just ask the court for that additional time so we can actually get the information and discovery and visit with our client about it.
So did Miss Beasley have digital discovery, anything that she needed to give you?
Not yet, but we're going to make a exchange either later today, or I have some jump drives I can hand off, or we will figure that out as quickly as possible.
State, I would just ask that you amend or change your system to show that Mr. Ashmore's the attorney, so he has access to online discovery.
Yes, sir.
Thank you, Mr. Russell. You're free to go.
Judge, I will note for the court's record, I've already given Mr. Stevens, who has requested it, access as well. Just the court's aware, we're trying to keep on top of that as best we can.
Thanks, sir.
I did know about that from her. So
All right, I just want to make sure you were all the way.
Judge, I need to excuse the probation for just a second.
Sure. Yeah, so I'm going to Deputy McLeish, you want to go ahead and call some names? Efficient use of our time. Yes, sir. I show first page Ernest Bowie or Louis.
Yes, sir.
I say Bowie. David Bowie.
I'll do it both, just in case.
You're going with like James Bowie. You're going with David Bowie.
We'll see how froggy I feel.
Frog for good. And we're also going to call Sergio Villarreal.
Okay.
Just like that. Villarreal. Roll your R's. Very we're also going to call Leon Baker. Damon Gutierrez.
Yes, sir.
You haven't had any information on Damon Gutierrez, have you? Also, no.
Commissioner Durham. Jennifer Culpepper.
Jennifer Culpepper. and
Yeah, they have surrender of principal already.
Okay.
So, we'll need to call those names. Mr. Carroll, come on up, sir. CR 21-208.
Judge, we're here on a plea, to enter a plea on Mr. Carroll's matter. The state and defense have worked out a plea agreement of 6 deferred, which we're asking the court to approve. A little behind on the signatures. I apologize about that.
Mr. Carroll, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
All right. Mr. Carroll, are you a United States citizen? Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No, sir.
And in this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Yes, sir.
Look, you've had enough time to discuss your case with him, have all your questions answered.
Yes.
Is there anything about the paperwork that you've read and signed that you do not understand?
No, sir.
Mr. Ashmore, do you believe Mr. Carroll to be competent today?
I do, Your Honor, and I apologize. My colleague, Mr. Woodwhite, pointed out I have not got this sworn.
That's okay. I'll swear.
Okay,
I'll swear.
may I approach?
Yes.
Yes, my client is competent. We have discussed the punishment range, we discussed the advantages to deferred, which gives him a path to getting his citizenship back. He is a first-time offender. It also opens him up to the possibility of the full range of punishment if he does not comply with the promises and agreements he's making in that probation agreement, contract. So he's well aware of that, and we've discussed that. And we're asking the court to approve that so Mr. Bryce can take care of his business and get his.
Have y'all talked about the advantages and disadvantages of a deferred plea?
Yes, Judge.
Does he understand what a motion to adjudicate means?
Might be better if he was admonished by the court about that.
All right, Mr. Bryce, Mr. Carroll, you are charged with a second-degree felony offense of possession of a controlled substance of penalty group 2 greater than or equal to 4 grams, but less than 400 grams. The range of punishment for a second-degree felony is confinement in the Texas Department of Criminal Justice for not less than 2 years or more than 20 years, and a fine not to exceed $10,000. Any sentence that you received in this case, if you were convicted and sentenced by either a court or a jury, would have to be within that range. Okay. And I see in this case that the agreement that you want to enter into with the state is that you would plead guilty to that charge, and the state would recommend that you not be convicted of the offense, but rather you be deferred and you be placed on 6 years community supervision or probation, with you paying a $3,500 fine, $290 court costs, $785 reimbursement fees, and $180 restitution, with the state agreeing to dismiss an unlawful carrying of a weapon, with you also agreeing to forfeit the weapon seized in this offense. Is that your understanding of the plea agreement? So, Mr. Carroll, do you understand that if the court approves this and I place you on community supervision, if later during that probationary period you violate any one of these conditions, the state could file a motion to adjudicate you, that means convict you, and they could ask this court to revoke your probation, and they could ask the court to assess your punishment anywhere between the minimum 2 years to the maximum 20 years. You understand that? So understanding that that's the potential risk in this case, do you still want to go forward?
Yes, sir.
All right, court will ask you at this time then, Mr. Carroll, how do you plead to that offense? Guilty or not guilty?
Yes.
Are you pleading guilty because you are guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Court will accept the defendant's plea of guilt. Mr. Ashmore, any objection to the state's evidence?
No, Your Honor.
That states evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state,
No, Your Honor, we would rush to close at this time.
from the defense?
No, Your Honor, thank you.
State, is there a lab in this case?
Yes, Your Honor.
I'm not seeing it. It's
I will be happy to print it out right now for the court's information while technology is working. The lab tested to an amount of exactly 4.98 grams of the substances tested. They did not test all of the substances. Court is aware of the lab. Handles such things.
Every now and then. That was good. Yeah, that was nice. I don't know how to put it back. All right, Mr. Ashmore, any objection to this as states exhibit 2?
No, Your Honor, that's the exact same document we reviewed before.
All right, states exhibit 2, lab report is admitted. All right, the court has reviewed the evidence, finds that there is enough evidence to convict Mr. Carroll. The court will follow the plea agreement in this case. The court will defer a finding of guilt, place Mr. Carroll on 6 years community supervision, assess a $3,500 fine, order him to pay $180 restitution, $785 reimbursement fees, $290 court costs. Court will dismiss under section 1245 DA 2021-576 unlawful carrying of a weapon. Court will also order the forfeiture of the weapon seized in this case, specifically a Ruger SR9C, serial number 334-61997. Mr. Carroll, you turned 20 this year, didn't you? You've been on probation before, felony probation like this? What do you have planned for your life? Like, what do you want to do in your life? Have you not thought about it? I mean, you're not out of high school long. Are you working? Are you in school? Or are you just, what are you doing?
Working.
Working, what are you doing?
I work in a warehouse.
So when you wake up in the morning, you think about what you want your life to be. What do you think about? What do you aspire to do with your life? You're 20 years old. You need to start thinking about that. If you don't have a direction on where you're going, you're going to end up doing stuff like this. And then I get to determine your direction. You're going to have the government in your life for the next 6 years. I'd hate to see you violate your probation and go to prison for up to 20 years. There's no need for that. So I want you to start thinking about what your life goals are, what you want to do, and whether you get to decide. You get to really decide. Do you want to pick out what you wear every day, what you eat, where you go, what you do? You get to decide that right now. If you violate this, you don't get to decide that anymore. You're going to wear the same thing that all the other inmates wear. You're going to eat everything that all the other inmates eat. You're going to go to the yard when they tell you to go to the yard. You'll be watching your back. You'll be looking over your shoulder. You'll be doing all of that. It's not hard. That wouldn't be a hard choice for me, and I hope it's not a hard choice for you. All right? All right, Mr. Carroll, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence, and maybe come forward with my deputy here, be fingerprinted. After that, come over here and speak to Officer Ventura. She'll give you information on the next step. Mr. Forey, are you ready? You ready?
I am right there. I'm sorry.
Judge, if you remember, Mr. Foley, Lori, was having medical issues and had,
I'll be taking this for his docket moving forward.
Oh, good. Thank you, sir. We'll try to make that change.
It'll take a while. I understand.
All right, Mr. Jackson, this is cause numbers CR 21-173, 2021-362. CR 21-22. Jackson, if you'll raise your right hand, sir. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Your name is Damon Drake Jackson, is that right?
Yes, sir.
And Mr. Jackson, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition? In this case, you are represented by your attorneys, Mr. Flory and Mr. Dahman. Are you pleased with their representation of you?
Yes, sir.
Feel like you've had enough time to discuss the case with them and have all your questions answered?
Yes, sir.
Is there anything about these plea agreements and the paperwork that you've read and signed today that you do not understand?
Yes, sir.
And Mr. Dahman, do you believe that your client is competent today?
I do, Your Honor.
And have you explained to him his legal rights and also the advantages and disadvantages of a deferred adjudication plea?
I have, Your Honor.
Do you believe he understands them?
I do.
Mr. Jackson, in CR 2122, you are charged with assault of a public servant, which is a third-degree felony. A third-degree felony carries a range of punishment of not less than 2 years or more than 10 years confinement in a institutional division of the Texas Department of Criminal Justice and a fine not to exceed $10,000. And in CR 21173, you are charged by indictment with a
Impeding, Your Honor.
you're charged with assault of a family or household member by impeding. However, it looks like that charge is going to be pled to a lesser included assault causes bodily injury of a family member, family violence, Class A misdemeanor. The Class A misdemeanor carries a range of punishment of confinement in the county jail for a period not to exceed 365 days or a fine to exceed $4,000. Do you understand the range of punishments for each one of these crimes?
Yes, sir.
You understand that if I place you on deferred community supervision, like your plea agreement's asking me to, if you get on probation and you violate your terms and conditions of your community supervision, the prosecutors for the state can file a motion to adjudicate you or convict you and also ask the court to revoke your probation. And at that hearing, if the court finds that you violated any of the terms of your probation, the court could revoke you, convict you, revoke you, and then assess your punishment anywhere from those minimums to those maximums. So on the third degree, up to 10 years in prison, on the assault, up to 1 year in the county jail. Do you understand that?
Yes, sir.
Understanding that, do you still want to go forward with these pleas?
Yes, sir.
All right, so Mr. Jackson, to the charge of assault of a public servant, how do you plead?
Guilty.
And to the charge of assault causes bodily injury, family violence, how do you plead?
Guilty.
And are you pleading guilty to each one of those crimes because you are guilty of committing each one of those crimes?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty to either one of these?
Yes, sir.
Court will accept the defendant's pleas of guilt in each case. Any objection to the state's evidence?
No, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession in each case respectively. Any victim compliance issues, victim notification of state?
Judge, on CR 21173, the state has reached out to the victim, I believe a number of times. We've been unable to reach her. We've sent victim impact notification, have not received any response to those documents back to our office.
What about with regards to the?
I have personally spoken with Constable Mickey Henson. He is aware of the plea. He does not have an objection to this based on the facts of the case.
Anything further from the defense?
No, Your Honor.
All right, the court's reviewed the evidence in each case. The court will find that there is sufficient evidence to convict Mr. Jackson of each case. Court will follow the plea agreements and the recommendations of the state. With regards to the charge of assault on public servant, the court defers the finding of guilt, places Mr. Jackson on 8 years deferred community supervision, orders him to pay a $3,000 fine, $290 court costs, $35 reimbursement fees. Court will take into consideration and dismiss under section 1245, cause number 2021-361, driving while intoxicated first offense, 2021-362, resisting arrest. Court will order this probation to run concurrent with CR 21-173. With regards to the offense of Class 8 misdemeanor assault causes bodily injury of a family member with family violence, court will defer a finding of guilt. Court will place Mr. Jackson on 2 years deferred community supervision, order him to pay a $100 family violence fine, and will order him to pay court costs of $270 and reimbursement fees of $35. Court will order this probation to run concurrent with that of CR 2122. All right, Mr. Jackson, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted with the deputy. After that time, report over here to Officer Ventura. She'll give you further information.
Excuse your honor.
Yes, thank you, sir. Appreciate you being here.
Yes, exactly. Okay, I'll just. And then you'll just leave that after signing.
Those two will go with that. Almost, I think.
Court, may I use the?
Yeah, let me get us on the World Wide Web here. All right, Deputy McLeish, were there any announcements when you called those names? Was Bowie, Villarreal, Baker, Gutierrez?
There was no response to any of those.
All right, court having called the names Ernest Bowie, Sergio Villarreal, Leon Baker, Damon Gutierrez. Court finds that they received notice of today's hearing. They failed to appear. Their names were called at 9 a.m. They were not present in the courtroom. Court has had their names called loudly and distinctly 3 times in the courthouse with no response. Court hereby issues judgment nihil alias capias in each case. Court will be adjourned until the afternoon docket at 1:30 and will be streamed same time, same channel.